Hey, what's up? What's up? Doug from Salt Lake. Okay, so we had a little issue with Movavi yesterday, my screen recorder. So here's the motion to dismiss, motion in opposition to their motion to dismiss. So let's go through this here. So, of course, Douglas Mooney through Douglas Mooney. Here's your all cap. Here's your all cap. Motion in opposition. Here's the case number. Here's the judge. Well, the clerk. So, pursuant to your rules of civil procedure, the authorized representative of the plaintiff moves this court to deny the inevitable motion to dismiss from the defendant's counsel and respectfully demands that this court follow Rules of Evidence 201E and allow this man to be heard. So, what is Rules of Evidence 201E? And I don't know if you guys know or not, but most courts follow federal rules. So this is coming from the federal rules of evidence. Even though we're in state court, they usually follow precedent. So you've got judicial notice of adjudicative facts. This rule governs judicial notice of an adjudicative fact only, not a legislative fact. Okay, so this is basically rules for the court, evidence, kinds of facts that may be judicially noticed. Okay, and right here it has, this is 201, and we want E, which is an opportunity to be heard on timely request. So we are requesting. A party is entitled to be heard on the propriety of taking judicial notice and the nature of the fact to be noticed. If the court takes judicial notice before notifying the party on request is still entitled to be heard. Okay? So, found it, liked it, gonna use it. So, 201E and allow this man to be heard, right? So, I'm basically putting in my motion in opposition to their motion that under the rules of evidence, I would like to be heard. Respectfully, the alleged grounds for the motion to dismiss under 12b-6, that's what they always go with, failure to state a claim, are based on presumptions, assumptions, are not based in equity, and as stated before, statements of counsel are not sufficient for a motion to dismiss. Okay? We went through that. Trinsley versus Pagliaro. All assumptions of counsel must be dismissed for lack of standing. Okay? A simple order to show cause will destroy their off-point arguments because they know if a man comes into this court armed with the facts, he will prevail. That's why they always want to dismiss everything. Federal court denied me a remedy using the excuse of diversity. Go back and watch those videos. State court denied me a remedy regarding the divorce. This is a court of equity and must afford a remedy. This case is not about those cases. It is single and separate. It is about equity. It is all commercial. It is all about creating debt. This court knows that the plaintiff and the authorized representative are not one and the same, and that this court, ORS and the like, only have jurisdiction over the all cap name creation. Once this man rebuts joinder and comes to this court in his proper person, in motion, under the correct non-statutory label, this court cannot deny I have rights. Once ORS claims that a private man owes it something, they better have a contract they are enforcing and admit this into the record. If not, it is color of law. This court will notice counsel never addresses the fact that this case has already been settled. This court will also notice counsel never addresses the administrative process conducted by an officer of the state, a notary public, and has no defense as to its validity and substance and its contents. Let's see. And has no defense as to the validity of and substance of its contents. They call it a legal theory. but the meat of the process is not denied. Counsel repeatedly and exhaustively projects an assumption into this case that I have not stated a claim. That is false. The plaintiff's claim is clearly and completely claimed as estoppel. ORS claims they are enforcing a judgment, but they are a third party to this alleged judgment and have not provided this court with any proof that they are a party in interest. They have not proven my consent to their jurisdiction, nor have they provided any evidence they are not bound by the FDCPA. Remember, on the last one, all appellate courts have ruled that child support is a commercial debt. And if it's commercial and it's a debt, then it's under the Fair Debt Collection Practices Act. Counsel's table of authorities, while very impressive, does not apply to private individuals. It only applies to legal fictions. And you know that. Family law is private law. Why is it private law? Because it's between a man and a woman, between two living humans. Both parties must agree to the jurisdiction of the court, consent to it, which I did not. Therefore, this alleged judgment is void from the beginning. I have litigation pending against Chorus and TAC operating in their individual capacity, and I'm drawing those up right now. The statutes and regulations regarding judgments is false because, once again, please see the judicial notice with the controlling case law that I sent. We just did that yesterday. No judicial authority was present, therefore it is not a judgment. And for the record, I, Douglas Richard Moomey, categorically deny all points of the motion to dismiss seen as argument 1. Moomey's complaint is untimely. False. It's not untimely. Counsel is talking about the divorce, not the administrative process. Plus, jurisdiction can be challenged at any time. Okay? We've been through all those before. Okay? Something that's void from the beginning does not, through time, all of a sudden become okay. So, argument 2 that they had was the statute of limitations. It's false. There is no statute or run on a judgment void from its inception. This only applies if the court was granted jurisdiction, which it was not. Case law from upper courts on this subject is endless. This has nothing to do with my process. Okay? So what did they come at me with? It's untimely. Wrong. You're talking about divorce. You're talking about the divorce 15 years ago. I'm not talking about that. I'm talking about the administrative process. Okay? Statute of limitations. False. Okay? It doesn't, all of a sudden after 10 years, it's lawful. Now it's legal. No, it doesn't work that way. Okay? Argument 3 was that there was no contract. False. ORS isn't, they said that, they literally admitted that there is no contract and there was no contract that had been made through their non-response. And I said, okay, well, I'm going to go that way in my next document. But if there's no contract, then what are you enforcing? If we don't know each other, then who the hell are you? So anyway, no contract, false. ORS is enforcing something, but somehow they are an alleged party, and somehow a third party with no evidence of a claim can confiscate private property and use it to offset public welfare expenditures. And that's what they're doing. That's exactly what they're doing. And use a man for the surety for some legal scheme to engorge the state treasury with federal funding. They must be in contract with the private, so there must be a contract with this private man. And there is none. So, argument 4, constitutional claims, false. I have rights, and I have now, and I'll try to download and get this motion to dismiss. It's 15 pages. It's just gobbledygook, man. It's the same shit that they always send. Oh, we don't have to tell you nothing, and we're immune, and unless we consent, all that crap. It's just they take case laws and they take a bunch of codes and statutes and try to throw them at you, even though we all know that stuff only applies to them. It doesn't apply to me. Okay? Show me the contract, motherfucker. Okay, sorry. Constitutional claims. False, because I have rights, and I have reserved all my rights. Most importantly, my right to contract and all presumptions and assumptions of joinder have been rebutted. Okay, we'll get to that here in a second. If ORS can force a contract, then I can force a contract because all are equal under the law. This could have been avoided if they would just prove their claim. And then again, there was 4A, and 4B. So ORS is a corporation. The state of Utah is a corporation. Salt Lake City is a corporation. For God's sakes, it says it on the side of their vehicles. And that's true. It actually has their seal on the side of their trucks and their park and recreation vehicles and all their guys that, are downtown doing maintenance and all that. It says Salt Lake City Corporation on it. Okay. State of Utah is a corporation. We all know that. Okay. There is no de jure government anymore. So you're all corporate. Okay. Commercial contractors. Black's Law Dictionary clearly defines persons as corporations, businesses, trusts, and operating equity. They are single and separate, and a 1983 case is reasonably plausible. So that will probably be the next one because I'm going after everybody in their individual capacity. So ORS is not the real de jure government. Conclusion. Douglas Richamumi is a private trust. There's my UCC filing number if you want to look it up. Colorado State includes an unrebutted superior claim on all property of the trust. Affidavits. These are filed with the Salt Lake County Recorder's Office under miscellaneous. There is a estoppel at law, nunc pro tunc. Okay, I rescinded all their authority for lack of full disclosure. There is an affidavit of truth and an affidavit of sovereignty. Okay, they're all filed with Salt Lake County Recorder's Office, presented as evidence with this judicial notice of precedent as Exhibit XYZ. Okay, a security agreement between myself and the trust is recorded, and any infringement is subject to the terms. I have control of my assets. I have control. Okay? You don't own anything, you control everything. Okay? David Rockefeller said that. You put everything in a trust, and you control the trust. You become the trustee, you become the controlling manager. My labor, my trust, my life, my property, and unless ORS is a registered claim on me or the trust, they are operating outside their jurisdiction. And hopefully they will come into court and say, well, we have a claim, and it's filed with the 3rd District Court, because I happen to know that they have one of these secret little filings that they do that's an in-house lien that they put on you, and they don't put it out in the public. It's private. Okay, because they're private corporations. Okay, so ORS and the 3rd District Court are a couple of scumbags who do this private. I got an email, man. I'll show you the email one of these days. But it's basically the court clerk saying, we have a judgment against you, which is a lien. Okay, it's a lien. And it's not against me, it's against the all cap name. So they're attacking property that does not belong to them and have not provided the secured party trustee with any evidence of a debt. Therefore, having addressed this motion, I respectfully move this court to protect the private rights of this man and deny this motion to dismiss. I would also ask this court to review my administrative process, confirm its validity, and the coming motion for summary judgment should be granted. Notice of request for a hearing to unpack any questions should be granted if you need it. Okay, I'm willing to go in there and just mob on them again. So, plus I want to go back to court anyway. I need some more experience in court. And so, yeah, the more you go to court, the more experience you get. So let's see. Plaintiff will send controlling trust documents to the judge marked private, which I did the other day. Mr. Stone, okay, I'm not talking to Mr. Andrew Stone, all cap. I'm talking to Mr. Stone, your individual, okay, the man. These documents are not for the public. They are private and they should remain as such. I understand this court operates in a statutory, colorable jurisdiction, and I have corrected my status. Respectfully, I would ask you to review these documents as I am required by law to produce them when I claim they exist. It's very simple. I have proof of claim. ORS does not. Plaintiff has a clear and well-pleaded complaint which invokes the correct jurisdiction, which is equity. Plaintiff seeks relief in the form of summary judgment based in part on the very specific language used in contract law. ORS has agreed to the terms. ORS has created the estoppel. I didn't do it, they did it. Remember, anything done without consent, under threat, duress, or coercion cannot stand, and I should be afforded remedy. You don't need to order ORS to pay me. This isn't about the money. It's about justice. My administrative process has perfected the case. It has already been decided, and by silence, they agreed to the terms. Read the process. Motion to dismiss should be denied. Okay? And of course, certificate of service. And that brings something else up. I have been trying to contact Mark Corris and Michelle Tack, the so-called judge and the so-called commissioner, and I sent in a notice that I demanded that they set aside my judgment, and I think I'm going to make a video about that right now. Okay, guys, peace.